Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In today's episode, we're exploring a pivotal Labour Court judgment in the recent Nihal case, which is the National Education, Health and Allied Workers Union case, which centered on the employment status of community healthcare workers who for years have been subject to recurring fixed-term contracts without clear justification from the Department of Health. Now, the court reviewed whether the state's justification for these contracts aligned with the Labour Relations Act, specifically Section 198B5, which presumes workers in such roles to be permanent unless a valid justification is provided. The state argued that the contracts were based on a collective agreement, funded externally by National Treasury and linked to work of a temporary nature. However, the court dismissed all these claims. It found that the collective agreement merely regulated the conditions of work and did not justify the non-permanent status of these community healthcare workers. It also determined that the Treasury funding could not be classified as external since it funds all public service roles. Most significantly, the court acknowledged that the work performed by community healthcare workers is of a permanent and essential nature. As a result, the court ruled that community healthcare workers must be employed on an indefinite basis, which is a landmark victory for job security and a critical step forward for labor justice towards community healthcare workers. Honestly, when I think about January, I think January was super long. And when I think about how this year is sort of going, and now that we're in Feb, academic year has begun, how are you feeling about all of this, Debbie?
Yeah, actually, February is always a bit of a treadmill with back to the start of academic year, and we seem to wake up daily with a shock to the system and the spectacle of President Trump and Elon Musk's geopolitical drama and what its implications might be for us. So yeah, interesting time.
I think, to say the least, I think it's a busy year. There's so much happening already in the labor landscape, and now so much is happening that's impacting South Africa. And I think today's topic is actually no exception to that. So, as I said in my intro, this recent ruling, the Labour Court of Johannesburg ruling on community healthcare workers, has sparked a lot of discussion about precarious employment in South Africa, and I think particularly in the public sector. But today we're focusing on community healthcare workers. So I'm going to just dive straight into it. Debbie, what are your initial thoughts on this judgment?
So my initial thoughts, Asha, of course, I'm sure you would share them, is that this is a long overdue outcome. It's been a long struggle for the community health workers who have been entering into recurring fixed-term contracts and all the while performing a job which there's a permanent need for. I do wonder if we should be a little bit concerned whether the decision might have a chilling effect on employment schemes and programs, and whether the determination of the Labour Court that the contracts are of an indefinite period, whether this would have any cost implications that perhaps weren't clear from the judgment. Instead of determining the matter, the judge could have ordered a process for determining the dispute. But in any event, in this case, the community health workers, their right to indefinite employment appears unassailable. And yeah, my initial thoughts is that this is a good decision and a good outcome for labour justice.
I mean, I agree with you. I think this ruling is undoubtedly just a step forward for labour justice for community healthcare workers, because they've been on recurring fixed-term contracts for years, and the kind of work that they do, it's something that is of an indefinite nature. And that's why, this is why we're talking about it today, because it is a landmark decision. Now I want to ask you, how does this decision, do you think, highlight the challenges faced by community healthcare workers as well as other public sector employees on fixed-term contracts? Because that's also what we're highlighting today, this whole aspect of labor law, fixed-term contracts.
So in theory, our law has always offered pro rata protection, even for workers so on a fixed-term basis or a part-time basis. Quite apart from the job insecurity and the stress that comes from that for fixed-term workers, there's a history of abuse of fixed-term contracts, and that's a global phenomenon. And it presents significant challenges for not only public sector employees, but for all employees who are on fixed-term contracts. Of course, there are justifications for fixed-term contracts, and our law is clear on what those justifications are. And the provision, of course, here is dealing with fixed-term contracts of employees who earn below the earnings threshold, which is Section 198B of the Labour Relations Act. So it's a particularly vulnerable cohort of workers, and the challenges that they face are significant.
This judgment actually exposes how recurring fixed-term contracts can often be used as sort of this tool to circumvent labor laws. And I think it just leaves these kind of employees in a very, very precarious position despite performing essential long-term indefinite work. What do you think? What are the key implications of this judgment for workers' rights, particularly around job security and benefits?
So those workers, of course, who are now of indeterminate duration, there'll be significant benefits, in terms of job security, but also the broader implications for access to social security and benefits. Access of financing, mortgage bonds, all of these, are contextual and relate to one's ability to show income. The implications are significant for those workers who benefit from the provisions. Of course, there may be implications beyond that for workers who might still be employed in schemes, public employment schemes, where there might actually be a negative outcome in terms of whether the judgment has a chilling effect on governments and employers' willingness to employ workers on a fixed term basis. So that longer term implication, I think, is something we need to keep an eye out for. But for those workers who are implicated by the judgment itself, I would imagine this is a significant benefit and a victory in terms of having access to social security schemes and social protection.
If we look at our labor justice barometer scale. But before I ask the question, Debbie, I think we need to actually explain what we mean when we talk about the labor justice barometer scale. We spoke about this early on when we were discussing the whole conception of the podcast. So maybe just telling our listeners, what do we mean by labor justice barometer?
Sure, Asha. So the term labor justice, I think it's an ILO term, the International Labour Organization. I stumbled across it in a project with the ILO where, in the terminology that I was using was substantive and procedural fairness, remedies, and the ILO corrected me to tell me about this term labor justice. And so labor justice is around effective access to labor dispute prevention and labor dispute resolution. And then it sets out a whole number of effectiveness principles and tools for assessing, how speedy is the process. Is labor disputes resolved in a manner where there's accountability, accessibility, independence? So there's a range of terms that are used that relate really to what we would understand in our legal system as substantive and procedural fairness. At the time, and this was around 2023, I immediately looked for literature around the term, and I have a really nice document on called Access to Labor Justice, a diagnostic tool for self-assessing the effectiveness of labor dispute prevention and resolution. So we can provide a link to that with the podcast. So if any of our readers want to know more about labor justice or to use the term in their own spaces, that might be helpful. And of course, we tacked on the term barometer to that, using it as how do these cases or these development, how do they resonate with the concept of labor justice? Even in the ILO's context here, I think we do need to recognize that we have workers like these community health workers who fall within the radar of the barometer. But then there are workers, such as the artisanal or informal miners, which we discussed in our previous podcast, where this labor justice barometer, the radar is really far. Their access to those sorts of dispute resolution and prevention mechanisms, it's a much further journey that they have to travel to get into that labor justice space. So yes, I hope that's some context on this particular case using our barometer. Yeah, I think the outcome in the Nahawu decision, it's high on the labor justice barometer. It takes us right into the green, which is good because I also think you've previously lamented that we seem to always be discussing crises. What are your views on the outcome?
I agree with you. I think it is in the green. I think we've had a lot of cases where it's always, kind of going towards the orange or the red, or you're kind of feeling like, was this really successfully done? So it's really, I think it's definitely what this judgment has highlighted, this reinforcement of constitutional rights. And it is showing this protection that we have to give for community workers. And I think it is a victory for community workers. But I do think, and I'm not trying to bring us back into the orange and the red, but I do think we always have to think about this challenge of ensuring this implementation across other sectors. I'm very intrigued to see how this is going to be carried out. It will obviously need a lot of sustained effort to extend similar protections to other, precariously employed workers who are in similar circumstances. But overall, a great victory for community health workers, no doubt. You're listening to the Labor Justice Barometer, and we'll be right back. And I think that brings me to the question of what precedent does this case set for other public sector workers in similar situations? And, Debbie, how do you think this might shape labor justice going forward?
So I do think we need to differentiate between the sort of fixed-term funding that community health workers were subjected to, and there was this concession by the parties, and government conceded that the work that they were performing, there is a permanent need for that work. And there is another type of scheme or program that government runs, which is the sorts of programs that are providing unemployed workers with access to employment opportunities. But not necessarily employment opportunities in contexts where there's a permanent need or a specific skill that's being utilized by the worker. So I do think that we need to ensure that we are not having a chilling effect or curtailing these other types of employment schemes where fixed-term contracts may perhaps be permissible, but I suspect there's also room for abuse of fixed-term contracts in those spaces. There was an article in the news last week in which there was an about term on one of these projects. So it's the community work program. So it's community work and not community health work. At the end of last year in December, the Cooperative Governance and Traditional Affairs COGTA minister announced that funding was no longer available for fixed-term contracts, and this would have impacted on 67,000 community work contracts. So this was a significant, in a bleak way to it was, a Christmas Eve announcement, a bleak end to the year. I don't know whether that's an outcome or a consequence of the community health worker case. It may or may not be linked. And of course, public funding was one of the justifications that the state tried to rely on with the community health workers. Yeah, we live under the shadow of macroeconomic forces and, Trump directives and the like. The precedent, I think, if there are other public sector workers who are performing permanent work, and of course, outside of the labor justice immediate barometer, there's certainly some categories that we can think of workers who are performing public functions, but not even within the scope of fixed-term employment. It can have a negative implication or precedent in that we can see less of these opportunities being created because of a fear of indefinite contracts, or we can see a more positive. And of course, an indefinite employment contract, it's not that we don't permit termination of employment for justifiable reasons. So perhaps we need to overcome that fear also by, being more explicit about when dismissal is appropriate.
It just could call for broader reforms in the public sector. And I mean, we obviously going to dive into that. Maybe we'll have an episode where we talk about public sector employees and employment practices around this and just that enforcement of labor laws. But I also think what you've mentioned here is it's this immense pressure then on the government to address non-compliance and also protecting community healthcare workers in these instances. And it's something that we will have to dive into to kind of unfold as we discuss it, as the discussion progresses as well. The main consensus that I think we can take from today's episode is that on the barometer it was green, and in that way there are still elements to it that we will have to kind of build into, especially as we look at public sector employees. That's why we call it a landmark decision, especially because of the kind of work community healthcare workers do, and being on recurring fixed-term contracts. I think it exposes the dangers of fixed-term contracts as well. So thank you so much again, Debbie, for talking to us. It's always exciting, especially like you said, with the changing landscape and Trump's directives and the impact on South Africa, which seems to constantly occur. So I'm looking forward to the next one already and to see what we're actually going to discuss.
Thanks, Asha. So there's we are declaring this a victory, but there's one aspect that I didn't mention, which did occur to me, of course. This is a Labour Court decision. So we are in the space where there may well be a challenge to the Labour Appeal Court. And we haven't really gone into the detail of the rationale for the court's decision. So it remains to be seen whether this is the final word on the case. Certainly we hope that the employment of the community health workers is not jeopardized by any subsequent decision. But Aisha, thank you. It was great to speak to you again, and I look forward to speaking to you soon. Have a great weekend.
This podcast is not intended to constitute legal advice.